Please be seated, everyone. In the matter of State versus LH, may we please have appearances of counsel? Good morning, counsel, and welcome. Ms. Rowe, please go ahead.
Good morning, Your Honors. May it please the Court, I would like to respectfully request 2 minutes for rebuttal.
That's fine.
Thank you, Your Honor. Defendant was already a registered Megan's Law offender at the time that he committed the kidnapping and sexual assault spree that precipitated this case. Defendant had already been identified as the rapist and kidnapper by one of the victims, MH, by the time he was interviewed at the Bloomfield Police Department. Defendant was no stranger to the criminal justice process or the seriousness of sexual assault crimes when he filed 2 motions. First, to suppress his voluntary Mirandized statement to Bloomfield police officers, and second, to suppress the properly recorded out-of-court identification made by victim MH. The trial judge properly exercised his authority when he denied both of defendant's motions. The appellate division, however, improperly reviewed the case, and from its improper factual findings flowed improper legal conclusions. Having reviewed the defendant's statement and heard firsthand testimony from one of the interviewing detectives, the trial judge was better situated to review the Mirandized statement that defendant gave. Moreover, the judge was in a better situation to evaluate the out-of-court identification issue, having heard testimony and having had the opportunity to review the Bloomfield Police Department identification reports and the identification packet for himself. The trial judge accepted defendant's knowing and voluntary guilty plea, as these decisions by the trial court allowed the state to negotiate a guilty plea. This court should reverse the appellate division's improperly reached reversal and reinstate defendant's convictions. I waive the remainder of my 5 minutes and am happy to answer the court's questions as I discuss first, defendant's voluntary Mirandized statement, and second, the properly recorded identification made by MH.
So let me start by asking you a question. One of the Miranda warnings is anything that you say can and will be held against you, correct?
That's correct, Your Honor.
And the police officer told the defendant, the truth will set you free. That may be true in the Gospels, but it doesn't seem to be true in the course of a confession. Aren't those two entirely contradictory?
No, Your Honor. When you look to the context, if you don't mind, Your Honor, I forget exactly which page that appears on, but in evaluating Mirandized statements and looking to see whether it's a voluntarily given statement, one has to look at the totality of the circumstances. And this entire confession is rife with warnings that the officers gave that defendant was, in fact, in trouble. I forget the specific, I remember the specific quote to which you're referring, Your Honor, but I forget the specific page.
Do we agree that in the context of a confession, the truth will not set you free?
Not necessarily, but when taken in the context of the entire confession, the defendant understood that this wasn't this wasn't Sunday school.
Well, there were other parts where the defendant is being told that he doesn't have to be worried about going to jail that day. And that they were going to get him rehabilitation, we're going to get you help, the whole bit. And the general tenor seemed to be, you're going to go free as long as you cooperate with us.
The general tenor of the conversation was that if you tell us the truth about what happened, we'll be better situated to get you help on the other side of prison. Now, at the time that defendant gave this statement, he had already been convicted of a sexual crime 3 years earlier, having served 1 year of prison time, having gone to Avenel, and then been released on parole supervision for life, and having counseling only after he had gone to prison. So he would understand that counseling would not be offered in lieu of prison, especially because these are much more serious offenses, and he knew that they were talking about.
So the offer of counseling is one thing, but what about the affirmative statements that you're not going to jail tonight? That's not going to happen. Not going to go down like that.
This was when put in its proper context, it's actually in response to defendant's pointed questions that seem to be calculated towards trapping the police officers into making a promise that they shouldn't make. And that's...
Am I going to jail tonight? Is that the question you're referring to? I'm looking at 74 and 75.
Yes, Your Honor. In this whole conversation, they begin to discuss the June 18th sexual assault. It's clear that they're talking about a very serious crime. In fact, pages earlier, minutes earlier, as it were in real life, the defendant had said he recognized that when he was pulled over by a police van with flashers on, he knew it was more than just a traffic ticket. And the officers had been repeatedly clear throughout that they were investigating him, that they had been following him for some time, that they had video evidence against him. Clearly that this was for something rather serious, and that whatever they wanted to talk about on June 18th would be quite serious.
So focus on the back and forth prompted by the defendant's simple question. It didn't read like a trap to me. You can explain why you think it is some sort of manipulative question. Am I going to jail tonight? And then the responses from the officers, 3 times saying no.
Saying, my reading, Your Honor, of no, not at all is in response to, is this going to be my last meal? It's essentially in response to perhaps the hyperbolic question that defendant's asking. Am I going to jail tonight? Is this my last meal? Essentially, is my life entirely over? And they're deflecting him.
Why? I don't understand. Why is it hyperbolic? Am I going to jail tonight? What's hyperbolic about that?
Well, what's hyperbolic about that is that he knows he's on parole. In fact, he's been complying with his parole requirements pretty well, aside from committing these crimes. Even just a month earlier, he had registered at his new address in East Orange. So he understands that he's on parole. And being a parolee, he would understand that any infraction, no matter how minor, would result in him going back to jail at a minimum, if not prison.
He wasn't told that. That wasn't given as the reason for why he was being brought to headquarters, was it?
No, but eventually at the end of the conversation, he does concede that that he's been on parole, that he understands the terms of his parole. And at the beginning of the conversation, he makes statements that show he understands that he's on Megan's Law supervision and that there's certain requirements that he has to fulfill. So he's well aware of what parole entails and what infractions will do to his life. The defendant's characteristics are the lens through which these statements and everybody's responses and questions should be viewed.
But this seems to be a general theme throughout this interrogation at various other parts. I'm looking at Detective Harris, the defendant. The help I need is not sending me to jail, is it? Not at all. Nobody gets rehabilitated in jail. Yeah, I agree. This is the detectives. Nobody gets rehabilitated. It goes with the truth will set you free, the piece that the Chief Justice read to you seems to be lulling him into the belief that if he speaks with them, if he gives them information, if he confesses, everything's going to be fine, you're not going to jail.
Perhaps for a less sophisticated defendant, but this defendant is situated at 26 years old. He's already been convicted of a similar offense. He's already been to prison. He's already been Mirandized before. And actually, at the end of his statement, I believe it's page 157, if I'm correct, Lieutenant Krentz asked him, did they give you counseling when you were in jail for the year? Mr. Harris, no. Lieutenant Krentz, they didn't give you any counseling. Mr. Harris, no. Detective Fano, because that's what you need. In this context, defendant understands that he would not be rehabilitated in prison because that's not the function of prison.
I know that you keep on talking about the back end, but then one of the detectives starts talking about his nephew. And that's another one of these lines. You know, we got help from my nephew. And there was no suggestion that the nephew went to jail and was getting rehabilitation on the back end, as you're suggesting that the defendant would understand it from these questionings. And it seems to be like a part of the tapestry of questioning that's going on here.
Well, it's a tapestry of questioning and a tapestry of permissible psychological tactics.
There's nothing really, you don't really learn anything about the nephew, do you? Just that he had a problem and he dealt with it. There's nothing about he did or didn't go to jail, is there?
Exactly. And there's nothing that even says that the nephew had acted on some sort of criminal sexual impulses. There's nothing to say that he had ever been arrested, that he had ever been charged.
You could read that exchange as referring to just trying to create a connection, referring to a nephew who had a drug problem or a nephew who was arrested for something entirely unrelated to sexual offenses.
Indeed, it could have been a substance abuse issue.
Yeah.
Some sort of problem.
Well, he did say a nephew who was going through the same thing.
It could
Captain
have-
Krentz said, he started that discussion by saying, I have a nephew who's going through the same thing, suggesting that same thing as what defendant here was being interrogated for, don't you think?
That might be too specific of a reading. Defendant, again, it's important that defendant's characteristics be taken into consideration here. Defendant would be savvy, having already gone through this, to know that there's certain psychological techniques. He even acknowledges them that, I forget which page it's on, but he does say to them, you're acting buddy-buddy, you're trying to get me to say things, and these are permissible tactics. The nephew story, whether it's even true or not about this gentleman's nephew, was meant to ingratiate themselves with the defendant, which is a permissible psychological tactic, so long as he's not stripped of his capacity for self-determination. And what matters in this case is that he's already been through this. He's an educated man. He's the equivalent.
You say he's already been through this. One of the lines during this interrogation is, the last time I spoke, he feels that he was basically framed. I told him the truth and it didn't work out for me. And he keeps on saying that. He seems reluctant to speak with them because of the bad experience he had in this last interrogation. Am I mistaken about that?
Justice Albin, I'm glad you brought that to my attention because there's 2 points to be made about that. First, in that conversation where he says, it happened so quickly last time after I confessed, I told the truth last time and everything happened so quickly, the officers immediately follow up with, well, of course it happened quickly. This was a statutory rape charge, essentially, and no matter what the level of consent was from that high school victim, it didn't matter what it was. So of course it would happen quickly. He had admitted that he had had oral sex with the 16-year-old girl from the high school where he was working as a 21-year-old. And they specifically say this case is different because all of the victims are adult women. There might not be the same rush because there's going to be more factors involved, such as whether consent had been extracted from these women or whether it was forced upon them. Now, with respect to it all goes back to the defendant's characteristics. He's already been through it before, and they made a meaningful difference. And the meaningful,
if he's gone whether he's going through it for the first time or the second time, this is what I want to understand. Why should we be encouraging or condoning outright deception? This deception that may very well undo the voluntariness of the statement, and also the type of deception that is directly contradictory to the warnings which tell the defendant anything that you say can and will be used against you. Why should we be condoning, encouraging all this questioning that's suggesting just the opposite? Go ahead.
It wouldn't be to encourage some sort of nefarious purpose from the police. It's to encourage police to use tactics that are shown to work. Psychological tactics work.
Sorry, Mr. Word, you said encourage police to use tactics that are what?
That work. There's psychological tactics that work. The state certainly is not entitled to hold all of the cards, and law enforcement aren't allowed to do simply anything during an interrogation. They are allowed to use psychological tactics so long as they don't strip the particular defendant of his ability, his capacity for self-determination. And his pushback, I'm sorry.
Please finish.
His pushback throughout the statement also indicates that he was not stripped of his capacity for self-determination. Immediately after the Miranda warnings, he pushes back and says, well, I've been here for a while before you read my rights to me, and they counter, well, we haven't talked to you. And he says, oh, okay, and he signs his Miranda warnings card.
So there is case law that permits a level of deception. We're here to help you, and so on, the psychological type of deception, coercion that may take place. Is there case law that encourages or permits officers to engage in deception about whether a suspect will go to jail in response to questioning?
Well, I would submit that those cases don't apply here because they never once said directly, and the trial judge made this as a factual finding, they never specifically said that you will get help instead of going to jail. And it would be absurd of defendant who had been to jail for a lesser degree offense endangering the welfare of a child arising from that statutory rape to assume that he would not get prison time, that prison time wouldn't be on the table at all for much more serious sexual assaults.
Is it your argument that there was no deception on the part of the officer in responding to whether the defendant would go to jail that evening?
My argument is that they used psychological tactics to deflect his calculated questioning.
I'm not sure I got an answer to the question.
Yes, they used deceptive psychological tactics, but they were of the permissible sort, that they were allowing the interrogation to continue without defendant completely shutting down while still not stripping him of his capacity for self-determination, as indicated by his repeated efforts to trap them into responding to his questions, him giving pushback. He refused to give information at certain times and then explicitly said, I'm voluntarily giving you the names of these other people that I was with or supposedly with on the night in question.
It seems to me in reviewing the videotape and the transcript that there's not a statement that you are not going to jail for these offenses, but there is a statement about tonight as to a suggestion that you're going to be able to go home and, you know, you're not going tonight. What is the status legally of assuring somebody that at least tonight, this is not your quote-unquote last meal? Well, that was a bit dramatic, but you are that if they in fact conveyed to him, we're not saying at all that you're going to jail tonight. What's the status of that legally in terms of case law?
Legally, through the lens of defendant's background and what he understands the process to be, he should have understood that he would be going to jail, and that asking that double-pronged question of, am I going to jail tonight? Is this my last meal? The no, not at all was sort of perhaps a clumsy attempt to deflect, but an attempt to deflect and really more in reference to perhaps the last meal or trying to assure him you're not going to be immediately thrown into the cell right now. And I should mention that all of this is taking place at about 5 in the morning, after defendant had been arrested at around, I believe, 2 o'clock in the morning.
So there are actually 3 exchanges about the jail, and you focused on the first one. There are 2 more on page 75 of the transcript.
Yes.
And I think it's incumbent upon you either to tell us there's no deception in those responses, or there's deception, but it's permissible. I'm not quite sure what your position is. Can you clarify?
With respect to the first one, the am I going to jail tonight?
That's the first one.
That would be deception, but of the permissible sort, that it's merely a deflection when you consider everything else that's happened up until that point, including them warning him, we've been watching you, we've been
Let's go to the
following
second
you.
and the third.
The second one, with respect to how quickly everything happened.
That's not going to happen. It's not going to go down like that.
That is not deception. It's them talking about, well, there wouldn't be a rush to judgment in this case. It's meaningfully different from a statutory rape where it's rather cut and dry. As a matter of law, having oral sex with a 16-year-old girl at the high school where you work as a 21-year-old is always illegal.
You get that from the context of the questions
Context
posed at line 6?
Context of the questions, and also the fact that they have been discussing throughout the entire investigation, or the entire interrogation, what they want to talk to him about, something rather serious. As you read on page 75, Lieutenant Krentz says, look at me, look me in the face, and I'm going to tell you in the face, and I tell everyone who I interview in this room the same thing. I'm not going to bullshit you. I'm not going to bullshit you. If I'm going to lock you up, I'm going to tell you I'm going to lock you up.
Isn't that deception right there? I mean, why isn't your argument that this is permissible deception? I'm having difficulty accepting that there's no level of deception in the second and the third. I understand your argument on the first. Put it to one side.
In the rest of Lieutenant Krentz's monologue, he does go on to say, I've been in this game a long time. I told you, we knew where you've been, right? I believe that's a misspelling. I didn't lie to you. You're not here by potluck. There's video. We have you on video. We followed you, so we know. I'm not bullshitting you.
So just to be clear, the answers given on lines 12 to 13 and 17 to 19 are not deceptive? Is that your position?
No, they're deflections.
Okay.
But it's hard to reconcile that with what Krentz says at page 161. where he says, I told you from the beginning I was going to charge you regardless because we had you on video. And yet that seems to come out of nowhere because they hadn't told him right from the beginning that he was going to charge him. He
But
was
they didn't tell him about the video from the very beginning.
not from the very beginning, because he's asking, why am I here? Did you find something in my car? Is there a warrant? He's asking why he was brought to headquarters.
Yes. And on page,
So going back to my question, how do you reconcile 75 not being, it appears like an outright lie in light of what the officer says to him later, at 161, when he's already extracted the statements that he had hoped for, with the offers of help and these other methods that were being used by the detectives.
well, on 161, he does refer to the video. Now, to be sure, they
But he
didn't
says, I told you from the beginning I was gonna charge you regardless because we had you on video. I just don't see this transcript bearing that out. Is there something that I've missed in it?
With respect to an explicit statement that we are going to charge you from the detectives, no, your reading is correct. I also can't think of any situation where they say that, but they do say before any sort of confession is extracted from him, we have you on video, we've been following you, we've been having this investigation for some time now, we know about, I believe they even say explicitly, we know about the 3 victims, we know what
That's
you've
all
been up to.
pre-confession.
That's all pre-confession.
Do you have a page on that?
The confession begins,
Yeah, I know.
I
the
believe around
confession.
page 74.
Yeah, no, I know where the confession begins, but what's the first reference to we have you on videotape, multiple offenses, et cetera?
Let me see. I know on page 62, Detective Fano says, you keep coming up in our investigation. And then Lieutenant Krentz says, we want to make sure that we know where you've been. That's what I'm trying to tell you. Detective Fano says, we're not telling you everything we know. They talk about.
But they were telling him certain things. So let me just ask you this general question, and it'll express my concern. In addition to saying such things as the truth will set you free, we're going to get you rehabilitation, you're not going to jail tonight, they're now also giving him the particulars of some of these offenses. And it seems to me the combination of all of these things put together is a recipe for a potential wrongful confession. When you're giving particulars, you're not just asking, you're actually inserting things about the crimes as you're encouraging the person through deception to give them an account so you won't be going to jail tonight. Isn't that a recipe for this phenomenon, the wrongful confession?
Not for this defendant, Your Honor. Again.
Even putting aside,
I'm sorry, go ahead.
even putting aside this defendant for this case, the hypothetical defendant, all of these things put together, okay, I know you said for this, would you say that this would be the type of recipe where this could actually happen? You could be eliciting a wrongful confession.
It would constitute an opportunity for the reviewing trial court to consider, yes, all of these different things that take place during the statement. But again, our case law requires also looking at the specific defendant. So
When you compare what the little bit of information he was given with the full confession, and he even asks at the end of his confession, does that match up with what the witnesses told you, confirming that he had provided details that were not provided to him? It's much more detailed and more specific in terms of his confession than the little bits that were told to him along the way. Would you agree with that?
Oh, it's quite detailed, Your Honor.
Regardless of whether it's a defendant or any defendant, is there anything inappropriate about telling a person you're interrogating, we know these things about the crime, we know that we have video of it, someone was wearing a white hat, is there anything improper about that?
No, there's nothing improper.
It doesn't matter whether it's defendant or any defendant. There's nothing improper with doing that, is there?
They're allowed to say these sorts of things because there's a specific societal interest in having voluntary confessions from defendants.
Yes, but when you engage in these types of tactics where you're encouraging the person that they're going to go home free, the truth will set you free, and then you start giving all of the details of the crime, that is going to give an incredible incentive to a person who is not stout-minded to start agreeing with the police. And it's the reason why there is the phenomenon of wrongful confessions. It happens. We know it happens, correct?
It could happen for a less stout-minded defendant. In this case, I would submit this defendant is quite stout-minded. He even, in addition to saying, does this sync up with what the victims were telling you, he even asks them at one point, I believe it was with respect to either wearing the gloves or his disposal of the condom that he used with one of the victims at an entirely different place. He asked the officers, does that sound wrong? This is somebody who's contemplating every single word he's saying.
And in fact, he was not given the details of the crimes.
Certainly not about the condoms and the gloves.
Yeah.
He volunteered everything about the condoms, his modus operandi, which seems to be to eliminate DNA evidence, it seems. He's always wearing at least rubber gloves, if not cotton gloves, over them. He always has the condom that he takes with him. He puts in his car garbage can that he empties, according to him, every other day. These are not things that the detectives could possibly know about him. He's volunteering this information after having considered, well, perhaps I'll get some brownie points if I tell them this stuff. He's making calculated decisions throughout. Initially, when he begins the interrogation, he keeps his cards close to the chest. He refuses to even tell the officers about who he was hanging out with after his shift ended at 11 o'clock at night. He explicitly says, I'm not going to tell you, I don't do those sorts of things. But then as it seems that maybe he can at least make things look a little better for himself, he volunteers that information. He volunteers that information.
There's a suggestion in what he said that was almost suggesting there was some sort of consent operating here. I mean, he's really making a case for consent.
That's what he's trying.
With a couple of these victims. The third one, obviously not. She screamed, but and rang doorbells. But he seems to be trying to put the facts in there to make the case for consent. Would you agree with that?
I would agree. There's certainly some spin. He talks about how he approaches the girls to try to converse with them as though he's picking them up at a bar or some other place where it might be a little more consensual. He goes on to talk about, he asked the one girl what her favorite sexual position was, and she responds missionary, as though to seem as though she's engaging with him on a sexual level, that she wants to have sex with him. He adds mitigating factors throughout his narrative. He talks about how he didn't hurt the girls, how he told them, I'm not going to rob you. And that, I believe that's the point where he says, does that match up with what the victims were saying? He's trying to make sure that his version of the facts at least sounds like the most generous version of the facts the victims could have given about them. And they show his savviness.
Are there other questions about the statement? Anyone? Would you like to address the identification?
I would, Your Honor. Thank you. So with respect to the properly recorded identification procedure, again, like the Miranda issue, this should have been reviewed for abuse of discretion, and the appellate division did not do that. In both cases, I should add, the appellate division did not defer to the factual findings of the trial court with respect to Miranda or with the sort of pre-Wade motion that had happened.
Was the detective who administered the array a blind administrator?
Yes.
Who filled out the photo display report? It's signed by Detective Ruggiero. You know who filled it out?
The follow-up report, the supplemental report.
The photo display report is the one that identifies the 6 photos with numbers for 5 of them, and then number 3 reads suspect. Do you know who filled out that report?
Whose handwriting it is on where it says, I, Mariola Hernick, did at Bloomfield PD Detective Bureau on 8/8/11 at 9:24. Am I on the right page, Your Honor?
I'm looking at essay 58.
Okay.
The title is Photo Display Report at the top of the document, underneath the Bloomfield Police Department.
I am not sure who specifically, it must have been the signing officer who filled that out.
Doesn't that suggest that this was not a blind administrator? If the officer who signed it knew that number 3 was the suspect?
Well, she wouldn't have seen this page. She would have seen the pages that she signed. So you have the instruction page.
No. The administrator. I'm asking, was the person who administered the identification a blind administrator, or did that person know who the suspect was?
Apparently he did.
I'm sorry, I missed what you said.
Apparently he did. I apologize. Apparently he did. But the crux of the defendant's challenge was the recordation of the identification. So you do have, at least here, the instructions that were given to MH, the victim. She signed saying that they had either been read to her or that she had read them herself and that she understood the instructions, which is both a requirement under Delgado and the AG guidelines. Now, at the time, the AG guidelines and the Delgado recording requirements were essentially one and the same, and they were to comply with the AG guidelines was to comply with the requirements set forth in Delgado. And what's actually interesting in this case is that this case was decided, I believe, 3 weeks before Henderson was decided. So Delgado is the controlling law at the time that the motion.
So was there compliance with Delgado? Was there contemporaneous recordation of the dialogue between the witness and the officer?
Yes, Your Honor, in the sense that it was a detailed summary, which is permissible under Delgado. So on SA 59, it seems to be a direct quote from the witness, and she signed saying that all of the statements are true. She identifies photograph number 3 as, quote, as being that of the guy who grabbed me and raped me behind the abandoned house on Franklin Street in June.
That doesn't tell us precisely what she said, how she said it, and what gestures or other utterances might have been said at the moment that she looked at the photograph. That's a summary. That's not a contemporaneous recordation of the dialogue between the two.
It could be contemporaneous or as soon thereafter as practicable. So here,
As practicable. But when the officer is there and the conversation is ongoing and the witness is looking and saying whatever the witness is saying, that is supposed to be recorded. Am I mistaken?
It can be a verbatim recordation, but Delgado offers 3 options. There's electronic recording, there's a verbatim transcript of what transpired, and then there's the detailed summary. So
but the detailed summary is not the preference, even under Delgado. Delgado is saying, you know, if you can do an electronic recordation, it's not required. But the contemporaneous recording of the dialogue was mandated by Delgado. Am I mistaken about that?
You're not mistaken about Delgado. There is a preference for those other methods,
So
but
why wasn't that done here? Wasn't Delgado on the books long enough?
it was. I can't answer for why it wasn't done here. It seems that they had these identification packets that they had been using to create a sufficient record of what had happened during an identification. So they have the instruction page, which gives the dialogue between the officer administering the identification with the witness, explaining, here's the instructions, don't be persuaded by anybody else's opinion, you do not have to select any photograph, it is your choice alone that counts. All of the meaningful instructions have been recorded.
That's not the
If
dialogue.
Delgado meant to be interpreted the way it's suggested, then the only thing that would be allowed would be contemporaneous recordation. Delgado allows choices. The fact that one of the other choices was made doesn't make it necessarily contrary to Delgado, does it?
Exactly. Preference is not a mandate. This court preferred one method, but it explicitly said in Delgado that the other methods, including a detailed summary, are permissible.
The reason why Delgado said that is because understandably, there may be circumstances when you're not in police headquarters. There are identifications made on the street where you may not have pen and paper at hand. Here you have the witness and the police officer in headquarters, available electronic recordation, certainly a pen and a piece of paper. There's no reason why there shouldn't have been at least a contemporaneous recordation by pen, if not by some electronic means. Would you agree?
I would disagree. It would be difficult to have a conversation where one is taking verbatim notes on every single thing that transpired, and then the witness sneezed, and then the witness turned her head to the right, suggesting, some change in her demeanor. Here we already do have a contemporaneous enough recording of her demeanor, that she was calm and that she was focused.
Do we know that she said or did anything, or that there was any conversation going on other than what's reflected in the record? Do we know that?
There's not
Well, we know they put the picture in front of her, she pointed it out, and that was the extent of the conversation or discussion. We have no idea that there was anything that was not recorded that may have been said or done by any witness or anybody during that identification, do we? We don't know.
We don't know. If we choose to disregard the witness.
Okay, but as far as we know, everything that was said and done was recorded.
As far as we know.
Okay.
Well,
Tell me, why are you pushing this issue so hard? You didn't do so badly in front of the appellate division. They didn't suppress. They said, go back, have the hearing.
Well, at the time that this exists, the law that applied at the time was Delgado. Somewhat reading the tea leaves, Your Honors, from the Ibn Mark Anthony argument, I understand that there could be some policy shift. That policy shift should be prospectively applied because at the time the officers were complying with Delgado and the AG guidelines as they existed in 2012. It should remain undisturbed based on the trial court putting the state through its paces, the state putting on the identification packets that, as far as we know, contain everything meaningful that happened during the out-of-court identification.
but let me read to you. I want to read to you the words from Delgado, and I want you to tell me whether or not there has been compliance. Preserving the words exchanged between the witness and the officer conducting the identification procedure may be as important as preserving either a picture of a live lineup or a photographic array. When feasible, a verbatim account of any exchange between the law enforcement officer and witness should be reduced to writing. Okay, Delgado? Why wasn't it feasible for there to be a verbatim account? Tell me, what was there about this headquarters encounter between the witness and police that made it not feasible to have a verbatim account?
I don't know the specific reason, Your Honor.
And I don't want to use the witness as the victim's name, but did on SA 59, is it your understanding that is her handwriting?
On SA 59, it is my understanding that it is her signature. I do not know whether that's her handwriting.
So could and I'm just referring here not to her name and et cetera on the top, but could the middle section be a verbatim discussion of what she said? In other words, that somebody other than her was taking down what she said.
A simple facial reading suggests that this is MH speaking in that tone. It wouldn't be the witness saying that this is the person who grabbed me and raped me. It would be the witness to the crime. So yes, it certainly seems to be her words and a verbatim.
Her words may have been recorded on SA 59, and then we have the instructions that were set forth were presumably read to her by the officer.
Read to her, she read them. Either way, there was a communication between her and the officer about the instructions on how to proceed with the identification, and her signature confirms that everything on here she understands. It's been reviewed with her.
So is it the state's contention? Obviously, you weren't present.
I was not present. I was still in law school.
Okay, safe in law school.
Yes.
Is it the state's contention that between the instructions and this handwritten section, there is a verbatim recording of what occurred?
Yes, such that it would constitute in that detailed summary of everything.
Can you state with confidence that that is the entire exchange that occurred? And if you cannot tell us that with confidence, shouldn't this go back for a hearing where the witness and the detective testify whether or not this was a verbatim account or whether or not they were missed pieces of the exchange? Go ahead.
I'll start with first, I cannot.
Okay.
From Villanova, Pennsylvania, I could not tell you what's going on in Bloomfield, New Jersey at any time. This could be remanded for further proceedings, but it would seem that this court would be adding on to Delgado, that you would have a hearing before the hearing about whether the Delgado requirements were complied with when the trial judge, having already had the opportunity to look at the packet, look at the supplemental report that the state attached at, I believe, SA 63 through 65. There's a supplemental report that these together constitute enough of a detailed summary with verbatim quotes from the victim, with the instructions that were given. The trial judge already had the opportunity to review these and already determined that these complied with the judge mistakenly said Delgado, but referred to the AG guidelines, and to comply with the AG guidelines would be the same as to comply with Delgado. It seems perhaps excessive, perhaps an inefficiency in the judicial process to add another hearing before a Wade hearing to go through and determine whether the recording was sufficient enough.
The trial court did not take testimony. He was drawing the same inferences or assumptions that you are, and you quite candidly have told us you can't say with confidence whether or not that represents the full exchange, correct?
I cannot, but looking at it, the trial judge seemed to at least say all of the substance that's required of Delgado, all of the instructions that have to be given to the victim, all of the meaningful comments that the victim might make, that's all included in here. And if this is everything that matters, then the judge determined based on that there was nothing to merit further interrogation by way of a Wade hearing.
Anything else? Questions? Anything you'd like to add? We'll have you back on rebuttal.
Yes, yes, Your Honor. For 2 minutes rebuttal. Just to add, this case is really about the abuse of discretion standard and encouraging the appellate division to defer to the factual findings that a trial court renders when judging the motions that they judge every single day. They are best situated, better situated than the appellate courts to render factual findings, to take testimony, to look at the case. These judges often live with these cases for months, or in the case of something as serious as this one, even years, and they are in the best situation to determine whether something was a voluntary statement, whether the out-of-court identification complied with Delgado guidelines. And with that, Your Honors, the state would encourage reaffirming the abuse of discretion standard and affirming the defendant's convictions.
Thank you. Ms. Hubbard.
Good morning. May it please the court. The police did provide LH with Miranda warnings, but as it became clear that he was unwilling to inculpate himself, and he spoke about his concerns about losing the life he had built in contact with his young child, police preyed upon those concerns. Faced with a man who was reluctant to relinquish his constitutionally guaranteed protections, the interrogators began to make promises that any incriminating statements would be used to obtain treatment and not incarceration. As LH sat in an interrogation room with 2 detectives determined to get a damning statement, he expressed concerns about what a waiver of the right to not self-incriminate might really mean. The detectives, in response, repeatedly pledged that he would not be locked up. It was only after they explicitly and repeatedly made those assurances that he finally succumbed based upon their promises. Now, there's no question that everyone in the room but LH knew those promises were false. The detectives knew it. They knew if he gave the statement inculpating himself in a first or second degree offense, he would in all probability be spending the night in jail. Moreover, they knew that upon any finding of guilt for such an offense, only the court was in a position to determine what punishment would ultimately be imposed, and that given the severity of the accusations, it would almost certainly include imprisonment. Indeed, after the detectives had extracted the statement they wanted, they revealed what they knew all along, that LH would be incarcerated as a result of the words he spoke in reliance on their assurances. Their false promises contradicted the Miranda warnings that they had given. The detectives on one hand tell LH that anything he said could be used against him, but on the other, they told him it would be used to get treatment and not secure his incarceration. Those promises that he would not be incarcerated but would be placed in treatment were the type of promises that overbear the will of the person being interrogated and render his statement involuntary. Now, we know about these false promises because one of the things the officers did do properly was follow this court's mandate as enunciated in Rule 317 and record the questioning. Therefore, we don't have to guess about what happened. We know. Unfortunately, 2 days later, law enforcement chose not to abide by this court's mandates as announced in Delgado. one of the officers who had in fact interrogated LH called MH, one of the complaining witnesses, and asked her to come down to the Detective Bureau, the same place where he had conducted the interrogation of LH 2 days earlier. And he asked her to come down and view some photos. Now, on 14 prior occasions, detectives had been unable to secure a witness identification from MH or anyone else. But during this administration, which took place after they had extracted their inculpatory statement from LH, MH was able to select the photo of LH. But law enforcement chose not to record that identification procedure. Now, despite this court's direction that as a condition of admissibility, such procedures be recorded verbatim, or if not feasible, then be recorded in the form of a detailed summary, law enforcement chose not to make such a recording. Instead, they used they used leading fill-in-the-blank forms that failed to offer a verbatim account or a detailed summary. Among other critical pieces of information, the forms failed to capture the dialogue between the administrator and the witness. Any comments the administrators or others involved in the procedure may have offered to the witness before, during, or after the administration. Comments the witness may have made during the course of the ID procedure, or her confidence in that identification. Not only did the police fail to record the details of the identification procedure, but they failed to record the details of all the prior attempts they had made to get an identification. Therefore, not only do we not know important information about the administration done on this day, the day in question, where his photo was selected, but we don't know important information about those prior administrations and how those things or those procedures may have affected this selection. Consequently, the police offered an inadequate record that denied the defense and the reviewing courts crucial information about the identification the state sought to introduce. The record we have of the interrogation reveals false promises were made and that those promises served to overbear LH's will and seriously undercut the very Miranda warnings police were required to give him. This rendered the statement involuntary. The lack of a record that we have of the identification procedure leaves the defendant and any reviewing court unable to determine what occurred and the integrity and reliability of the process that resulted in the identification. Both the statement and the identification should be suppressed.
So your argument now, consistent with your brief, is that through the manner in which the questioning was conducted, the officers overbore the defendant's will, correct?
Yes, and it's particularly pernicious because it was about the constitutional right that they were required to inform him about concerning Miranda warnings.
So if you go to the video, you observe a back and forth that takes place with questions and answers on both sides in a respectful tone. There's no yelling or threats or anything physical taking place. Can you tell us in the video itself at what point the defendant's will is overborne?
Yes, so we don't have any physical coercion, and thankfully, and one of the reasons we have recording is that we would hope, most law enforcement departments are no longer resorting to physical coercion to get confessions or inculpatory statements.
Focusing on what actually happened here, can you tell us at what point in the interrogation the defendant's will is overborne?
So this court and others have ruled that you can have promises that are so enticing and promises also that confuse the giving of Miranda warnings, that when you give those promises to a defendant, at that point, because you've confused him about the warnings and also made a promise that's so enticing, his statement is no longer voluntary. So once the police I'm sorry.
Understood. So can you particularize that for us?
So when he asked, there's 3 different places that we point to. When he asked that if he's going to jail in response to their question about does he want anything to eat, and he asked, wait, is this his last meal? Is he going to jail tonight? And their response is no, not at all. Now at that point, he's still concerned, but we contend that that's where they begin to overbear his will.
Is there anything on the video, when you watch the video, the characteristics, the observations you make of both the officers and the defendant remain essentially the same? Is there anything on the video that indicates at any point that he was somehow breaking down or that his will was being overborne?
Yes,
okay,
this dialogue that I'm talking about, because he's asking.
Hold on. There's something you see on the video to that effect?
If the court is asking me if he's in a hump in the middle of the floor crying. No. If the court is asking me if I believe that
Slow down just a bit.
Yeah,
if the court is asking if I believe, however, that the words that the officers, the detectives are speaking to him are breaking down his will, yes, because they are telling him, one of the things you have to have involuntary, intelligent, and knowing waiver of one's right to not self-incriminate is one has to have an understanding of the Miranda warnings, right? And so here, when he is asking them, what he's asking them is questions about the import of that failure, or of his choosing to waive his right to not incriminate himself. And the officers are lying to him about that right. They're telling him that if he incriminates himself, it will not result in his incarceration. So at
night.
No, and that's very important to point out. I'm glad that you brought that up. So in the first instance, he says, am I going to jail tonight? Now, it's clear that, and that can be read two different ways. It can be read, am I going to jail tonight, meaning on this date, right? Or it could mean, is tonight the night that I'm going, are you going to send me to jail tonight? Either way, there's a lie about that. But then if we move on to later.
Is there anywhere where they tell him you are never going to jail for this?
Yes, they do. There's a discussion. So we move on. If we move on, but we started on page 74, verses 19, I'm sorry, verses.
Line 19.
Line 19 to 25.
What page, ma'am?
74, line 19 to 25.
Okay,
That's where we've talked about so far, and the question has been, he said, am I going to jail tonight? Then we move on to page 75, verses line 1 to 19. We all know where I was yesterday. Line 1 to 19. And there, they're telling him, no, it's not going to be like it was before. And they begin to say, we tell people if we're going to, it's not going to go down like that. We tell people.
But isn't that a reference to his comment, last time they locked me up immediately?
Right,
lines
but
6 and 7.
But that's not talking about jail tonight. And then later he moves on to say,
Sure it is.
is the help?
Sure it is.
I'm saying it's
He's
not
talking about-
limited to. I'm sorry.
He's talking, just read tell me if you disagree. He's talking at 6 to 11 about it happening that quick last time.
Mm-hmm.
Not whether he would ever or never go to jail, but that he went to jail that quick the time before, and they say no. Maybe deception, but is that deception of the sort of saying, you will not go to jail in this matter?
I don't read that to be a discussion about that portion to be a discussion about if he's going to jail that night.
What do you
That's a
make of it?
discussion about if
What do you make of the statement it happened that quick if it's not about immediately after the interrogation? When it says it happened that quick.
that I went to jail, I don't think that the concern is about if it's that night or not, particularly when we move on to the next point.
So what meaning do you give the 4 words? It happened that quick the last time. What meaning do you give to this if it's not about happening right after the interrogation?
I don't know, but what I'm saying is that
Isn't that a reasonable interpretation? It happened that quick, meaning, the last time I spoke, I was taken to jail immediately after the interrogation?
It could very well mean that.
Is
But
there
what
any
I'm
other
saying,
meaning?
his concern is not limited at that point to that night.
How do we know that?
Because if we move,
Go ahead, Justice Patterson, go ahead.
I'm sorry.
No, go
would
ahead.
you like me to?
No.
Okay.
Respond to his question. I apologize.
His concern at that point, especially when we look at the fact that they had been talking about you want to be with your daughter, he's talking about his daughter, his job earlier. His concern is not merely that night, particularly when we look at then page 81, lines 16 to page 82, line 12. And he says, at that point, that's when one of the detectives is talking about a family member who had a similar problem, and according to the detective, and then he says he's getting help now, and I hope he stays there. And then
Let's stay with 75 for the moment, because I think that's very much the focus of your brief and your argument. You got them saying we don't do this that way. He says it happened that quick. Then they say a reference to that's TV bullshit, dude. That's TV. This ain't TV. They use his name. It definitely gives a sense that they're responding, saying, when you see people carted away and arrested immediately or whatever, that happens on TV. That's got a short-term concept to it. Would you agree with that?
No, and I understand that Your Honor is reading it that way. I believe that the way I read it was that they are talking about the fact that they've been honest with him and that because the detective also said, when I lock up people, I tell them I'm going to lock them up, right? So we're not going to do that bad cop thing you see on television, especially when we look at the rest of it. And my brief.
I'm sorry. Go ahead. Are you finished?
My brief did not just focus on that. It gave the totality. So, for instance, when we look at page 81, where he specifically then says, is the help I need jail? And the officer's response is, it's not jail tonight. The officer's response is, not at all. Nobody gets rehabilitated in jail. This is not, when we are talking about his desire, and he mentioned, and they reiterate, his desire to maintain his job, his desire to maintain his ties with the community, his desire to continue to raise his daughter. That's not a concern about if I will spend the next 24 hours in jail, and that's not what we're talking about the next 24 hours.
Can you agree that perhaps that one wasn't, but the first one at the beginning of 74 is about that night, if you read it, the beginning? Am I going to jail tonight? Is this going to be my last meal? Or something like that? No, not at all. Well, that's what everybody says, and then that's TV bullshit, dude. That's TV. This ain't TV, Lee. Hey, listen to me. It happened that quick. The last time that something happened and that's when they're going to, I'm not bullshitting, you're not going. Can we agree that one at least is about going to jail that night?
I will simply say this. I believe that that LH was asking, are you going to lock me up today? And that does not evidence that his concern was simply about that night. However, even if your honors feel that that's what he was speaking about, the rest of the record discloses that that's not all he was concerned about and not all the officers told him about.
It is. That would be the first day of your incarceration. Like, why would that lessen it? You're going to be going to jail tonight. Doesn't mean that you're going to be released the next day. That's like the beginning of your jail term.
I'm saying that's not all that he's concerned about. That's what I'm trying to say, that his concern was about his life, his maintaining his relationship with his daughter, and it is clear that the officers and he are talking about his incarceration, not just what's going to happen in the next 24 hours.
To me, it seems it would be worse if they were lying about tonight rather than some indefinite time in the future. That's the moment he's really concerned about, right?
He's concerned about being locked up and not having his life. Yes.
And is it your position that the exchange on page 81 is an express misstatement that he will never go to jail?
Yes. He asked, is the help I need, because the officers keep telling him, we need you to give us this information so that we can determine what type of help you need and we can get you help. And then his response is the help I need jail? And their response is no, not at all. Well, sorry, not at all. Nobody gets rehabilitated in jail.
And that overbore his will because he was counting on, based on their representations or misrepresentations, on being essentially let go, correct?
He was counting on whatever the outcome or disposition of the matter being, it would not include incarceration.
Okay, and that is notwithstanding the fact that by that time, he knew they were questioning about 3 rapes, or 2 rapes and 1 attempt.
Yes.
He knew that. And he also knew that he had already gone to prison for statutory rape, for having relations with a young lady who was under the age.
My understanding that, yes.
So notwithstanding that knowledge, having spent time in prison on that charge, and having received some post-release treatment and being on Megan's, notwithstanding all of that knowledge, he's now being questioned about 2 rapes and an attempted rape, and they've now convinced him he's going home and he's not going to jail?
Yes, and in fact, they used his prior experience against him. He specifically, because one of the things, and the state points this out, well, we have to look at what his prior experience with the justice system was. And in fact, I believe that the judge in the law division made that mention. Well, here we have a situation where the detectives, specifically when he asked, when he was specifically asking, should I allow that prior experience, which he noted for them was his only prior experience with the justice system, to inform my current decision about waiver? And they assured him, in fact, told him, no, it's not going to be like that. They were telling him, don't import that knowledge you have from the prior experience to this situation.
What we hear from the state on that point is that the distinction that the officers were drawing is that in a case of statutory rape, there couldn't be, for example, a defense of consent, which it seems that he was perhaps interested in pursuing, that the fact of the sexual contact was the whole ballgame. That's what the state's, I'm not saying whether I agree or disagree with it, that's the state's response. So how do you respond to that?
That's not what the transcript bears out at that point. When he's asking that, they don't say, well, no, this is different because that was simply a statutory, I hate to use that term, but that was what the public would call statutory rape,
yeah.
and this was not. Actually, it was, and actually that offense, my understanding, just for clarity, was a matter where the complaining witness was 17, but because 17. He worked in the school, he had supervising.
Yeah, I apologize.
Power.
Did I say if I said 16?
No, that
they said
just
a minor. The comment to him is that was a minor.
Right.
That's what's in the transcript.
But they don't. They don't say to him, "This will be treated differently because, and you won't be going to jail tonight. This may take some more time or may take less time because of the nature of the offenses." His questions are things like, "Is the help you say I need going to jail?" And their responses are no. And those don't have to do with the fact that that was a different type of offense. When he brings up in the past when I told the truth and no one believed me, their response is this is different.
When they say no to the question, is the help I need jail, that could mean, could it not, you need counseling, and as to whether you're going to jail or not, we're not getting there. And that's certainly by the end of this, they were clear on that.
Well, they were clear on it once they got their confession.
Right, but I mean, the question, they don't say you are not going to jail. You were only getting counseling. They don't say that. They're saying, he says, is the help I need jail?
He asks, is the help I need jail? They respond, no, no one gets help in jail. He is asked earlier, am I going to jail tonight? They say, no, you're not going to jail.
There are parts of the back and forth where it appears that he's pushing back on the officers, almost as though he doesn't believe them. Like, for example, when he says, well, last time, happened real quick last time. What are we to make of that in terms of the question whether his will was overborne?
We're to make of it that he made the mistake of believing that officers wouldn't lie to him about his constitutional rights and the import of incriminating himself. What we have as a defendant who's faced with...
His pushback is an indication that he believed them.
That he's trying to determine what they're telling me, that if I waive, he might not use those words, but they're telling me that if I give a statement, it's not going to be used to incarcerate me. I'm not sure about it because the last time, but I'm just going to get some clarity from them. And they give him clarity, false clarity, but they give him clarity in 3 different ways. And when they say to him, it's not like you think, it's not like it is on TV, it's not like it was before, don't judge this situation by that past experience. It is only then, after at least in 3 different ways, they give him these assurances that he finally capitulates. What we have is a defendant who made the mistake of believing that law enforcement, the arm of the state, would not lie to him about his constitutional rights.
Would you like to move on to the identification?
Yes. Oh,
go ahead.
There is one more thing. I understand the state has argued that this is a situation where the appellate division overstepped its bounds. I simply want to note that in Mann, Harris, and Hinton, our judiciary has noted, we review de novo the trial court's legal conclusions that flow from established facts. And then in Harris, thus, we uphold the facts found by the motion judge to the extent they are supported by sufficient credible evidence in the record, but apply the law as we understand it to be to those facts. In this case, in this situation, no one, because the police hadn't recorded the interrogation, there wasn't a question about what happened. And the appellate division accepted the facts.
Why did they send it back for a hearing then if they accepted the facts?
They sent it back for Delgado. They didn't send it back for Miranda.
Oh, no, I'm sorry. I thought you were talking about Miranda.
No.
I'm sorry. I thought you were talking about the Delgado. I'm sorry.
But now we are moving on to Delgado.
Okay. I thought you had moved on.
So moving on to the Delgado situation, or the identification, just for, again, clarity, because I don't want there to be any confusion, the identification takes place after the police obtain their inculpatory statement. It's 2 days afterward. And
I asked you a question about the photograph that was selected.
Yes.
Can you tell us what was on it? Was there anything other than the number on that photograph?
sorry, we don't have anything in the record to suggest that there was something else on the photo. We don't know, but we don't have,
What about SA 60? Is that the array?
I'm sorry. Yes.
Does that help you in response to Justice Albin's question?
Oh, I'm sorry, you mean other than the number, or?
Is there anything at all other than the photos of the faces of the 6 individuals?
No,
It is what it is.
yes,
Okay.
we don't have any, at this point, we don't have any indication that there was something else. And I don't believe that was, that the trial attorney argued that either. The problem was that there wasn't a verbatim account, and in fact, there wasn't even a detailed summary.
Can I make a suggestion? Tell us why you think a remand is appropriate in this case. Recast your argument and answer that question.
I have to answer it in 2 parts only because
Go ahead.
I actually, and I did mention this in my brief, at this point, I don't believe a remand is necessary. But it's because of something that happened, and I mentioned it in the brief, that happened after the appellate division made their determination. However, if there was to be remand, I can also explain why that might be appropriate. So the reason why I don't believe a remand.
I'm missing, so I don't want to miss your words. You said you could explain why what?
The appellate division remanded the Delgado decision, but the appellate division did not have the arrays that the court has now were entered. They were identified and they were referred to, but they weren't entered into evidence in the law division, so they never came up in the record. And so the appellate division had to refer to what was in the record and what the law division judge said about the documents, but didn't have them themselves when they first issued their opinion. When the state then made a motion for reconsideration, the state appended the documents, and therefore they became part of the record for the appellate division's purposes.
Thank you.
Unfortunately, those.
Clarify one thing before you go on. The police reports that we have were not in front of the appellate division, correct?
Not when they made their original decision, none of it was.
And so the instruction sheet, the photo display report, and the third document of the 3 forms, Aptiv had those?
It is my understanding that, from what I recall, they didn't have those. But what happened was when the state then made a motion for reconsideration, these were appended to the motion for reconsideration. And so then they had them at that point. But I don't believe that they had them when they issued their initial decision.
Go ahead.
So when the appellate division made their decision, they talk about, based on the comments that the law division judge made, it did not seem that these were offered the verbatim recording that is required by Delgado. Now we have them. And we know, looking at them, that they don't offer the verbatim recording or detailed summary that's required by Delgado. So that's why I say at this point, I actually do not believe that a remand is necessary. However,
how do we know that? How do we know there was anything said or done by the witness other than what's reflected in the documents?
well, here's the problem. We don't know because they didn't record, and Delgado doesn't put the onus on the defendant. What we do know is it doesn't record what her confidence was. We do know that.
The onus on anybody. Wade hearing, indicia of suggestiveness. Hold on. Delgado requires that certain things be done so we can tell whether there's any of that going on here. As far as we know, based on anything anybody said or done or put forward, everything that was said or done in that ID is reflected in those documents. Is there anything to indicate that she said or did, or the officer said or did anything else?
Yes.
What is that?
Okay. Now, I want to preface this with, I want to answer that question, but I also want to be clear that the problem is that the defendant is left to guess. But in this case, and so it wouldn't matter, but in this case.
I'm just asking you. I mean, the answer may be, we don't know unless we have a remand and a hearing, but as we sit here today, what is there that anybody has before them to contend that something was said or done that's not reflected in the document?
Well, okay, then the answer is we won't know everything we won't know everything because they didn't record it. But what we do have is, for instance, we have, and the state has conceded, a situation where it appears as if the administrator was not blind, or at the very least, there's a question about if the administrator was blind, which in and of itself can lead to suggestibility. What we also know.
I'm not saying you're not entitled to a hearing. I'm just asking, in terms of the record of what was said, that recordation of what was said or done during the interrogation, during the witness identification. Is there anything that was said or done, as far as we know, that anybody has any evidence of, it's not contained in the document?
Yes, so for one, we know that the investigating officer called her to come down to the station. We don't know what was said to her. We also, and
Is that part of Delgado before the photo identification, what was said to bring him down to the police station?
so the way that would happen is she would be
No, I
asked.
just asked, is that required under Delgado?
We would argue yes, because she should be asked, or, why are you here? What did anybody say to you? Because all of that goes to why she's
But
choosing
you're
the
talking about,
picture.
there are different things. You're saying we should know what she was told to come down to the station and be recorded. Is that, in your understanding of Delgado, that's required also, that preliminary step? When they call someone on the phone to come down the station, that should be either recorded with a recording device or transcribed? That initial request to come down to the station?
Or at least there should be a question about
Is that?
why are you here today,
Do you
once
think-
she's there?
Do you think Delgado requires that? Is that your interpretation of Delgado? That's required also?
I think that it could be read to say,
I'm
when you want to know
going
the
to take that
dialogue
answer as no, it's
between
not
her-
required, since he said could be read to say. So you don't think it's required by Delgado? I'm going to take your answer, could be held to say, not as a no.
She's not going to agree with you.
I know that, but so let me ask you another question. You say you don't know what was said because only a little bit was recorded. Now, in this case, very little was recorded. If it had been longer, would you be satisfied? But you still wouldn't know everything that was said. Do you think that Delgado requires a statement or affidavit from the officer saying this is all that was said? Is that?
Delgado requires verbatim recording.
But how would you know if nothing was said here other than what was recorded or
Well, for
written?
one, these are the rudest officers ever, because we don't even have a.
Well, maybe they are. Maybe they're in a hurry. Maybe they are rude. But we're not here for politeness. I'm asking you, if it's a very short statement, would you be satisfied unless there's a statement, affidavit by the officer who did the interrogation saying, I certify or swear that this is all that was said? Is that what you think is required if it's a short statement?
No, I think what's required is for them to write out what's said.
But how do you know that that's not all that was said that day? That's what I'm asking you. If it's very short, do you think at the end Delgado requires the officer, if it's not recorded for where the recording device, do you think Delgado requires the officer to say, this is all that was said, whether it's long or short, to satisfy the requirement?
There has to be something to indicate that it's a verbatim recording, or a verbatim account.
That nothing else was said. Okay, so that's what I'm asking. You think that a requirement should be that at the end of whatever is written down, the account, it should say, there was nothing else. I swear or revert to that.
Well, I'm not going to say how the court.
Well, how would you know?
That, but yes, there has to be some assurance that this is the total account of what was said, of the dialogue between the two.
So what would
there
that be?
There does need to be some assurance.
What form would that take?
It may be an affidavit. I'm saying I am not going to at this point say that it has to be done that way. But yes, there has to be an assurance, because I'm not saying that
other than insurance,
Delgado requires.
Other than insurance, you wouldn't be satisfied, is what I'm gathering, by anything, whether it's long or short. You'd have to know from someone that that's all that was said.
First of all, yes, we would want to know that that's all that's said. But these forms, we know, are forms that are fill in the blank, and we have a situation where on 14, we have individuals who didn't follow the.
I'm not talking about the other 14. I'm talking about this particular one right now. The last one.
Well, the last one, we have them not following the guidelines either.
I'll talk about the recording of what was said. It says no, and that's it. And if that's all that was said, that would be an appropriate, complete recording. If nothing else was said other than no. So
Then they
that
can.
situation where it's very short, or even a situation where it's much longer, would you suggest that a requirement be set forth by this court that whoever does the recording must testify also or aver that that's all that was said, nothing else.
That would perhaps be advisable.
Are you seeking suppression or remand at this point on this particular issue?
On this issue, as I discussed in the brief, I think that this court can go straight to the suppression because now we have these forms and we know that it wasn't a detailed summary. It certainly wasn't verbatim. However, if there was a remand, they could, I'm sorry.
So if I may, so take the pre-call. Come on down. I want to ask you to look at some photos. We have Detective Fano's report, which contains a short summary of that conversation. It's at page SA 65 of the record, the last paragraph. Can you represent to us that that is incomplete?
Well, what it says to us is he told her to come down. It doesn't tell us what he said to her.
He said, I asked her to come to the Detective Bureau to look at some photos. The question is, was that it, or was there more? Are we in a position to know the answer to that question right now, such that it would tilt towards suppression?
What I believe this court is in a position to know is that there wasn't a verbatim recording and there wasn't a detailed summary. And the problem is we can bring these individuals in and we can ask them questions. Right. But at this point, this many years later, especially with and let me back up for a minute. Yes, I am concerned about it, or we are concerned about those who would purposely mislead the tribunal. But we don't need individuals who are purposely misleading the tribunal. All we need is decaying memory. All we need is individuals who don't understand the import of what they said and those words. That's why we require this recording. But what we also have here are forms that let us know they're merely fill in the blank, and that and forms that let us know they didn't record things such as her confidence.
And it's to be clear, Delgado requires more than just recording the dialogue. That's just one of the things. We said make a written record detailing the out-of-court identification procedure. The procedure. Pick how the photographs are shown, whether or not the photograph may be held for a long time, maybe there's hesitation. That's all part of the identification procedure. The dialogue is just one part of it that we identified. So there's more than just the dialogue. Am I correct?
Yes.
Now, it's one of the reasons that you're seeking suppression, because in Delgado, we said that it's a condition of the admissibility. You got to do this.
Yes, you did.
But we sort of later, in Henderson and the rule, we gave other options, correct? We modified that provision of Delgado. Would you agree? They give other options other than mere suppression?
If, at this point, there's no way this court did not say that defendants are left without the ability to challenge or determine if there was suggestibility. And on this record, no matter what happens, there's no way to...
It could, look, you could argue below that there was such a gross violation of Delgado that it's impossible to determine what happened at the identification procedure. Lost dialogue, lost gestures, and therefore the ultimate sanction has to be imposed, suppression. But should that follow up on a hearing? Would that be better served having a hearing on that basis?
I think, and this is what I would go back to the brief, in this situation, now that we have this record, we know that these things are lost and weren't recorded. And as I said, I would answer it in two parts. If the court feels that there should be a remand, we understand that was the appellate division ruling. But what we're saying is now with these documents, we know that there was not a detailed summary. The defendant has been, as the law division, as the attorney who handled the matter in the law division put it, she couldn't challenge anything because not only was there not a video or audio recording, but they didn't put it in their police reports.
So are you now urging the court not to remand? Or are you keeping that as your backstop?
As I That
have
is
the
a
right to
brief.
remain silent.
I don't want to incriminate myself. As I said, the defense understands, I guess our second choice, I will say, is
Okay,
the remand.
that's clear.
Because
That's clear.
we don't believe, we understood
You're
why they,
saying you
why
have
they.
the 15, you make a ruling now, but you're not withdrawing any request for a remand.
We didn't, what happens, we didn't make the request.
I understand how it
The
played
appellate
out, but
division-
at least when it came to us initially, that you were looking for that aspect of the appellate division to be affirmed. Am I correct about that?
We put in our brief even to the court. Now that we have these documents, we don't believe it's necessary. But if the court, remands it for a hearing, we understand that. But it's just that the reason that they remanded it, they said we want them to look at these things and consider it concerning in light of Delgado, because one of the problems was the appellate judge conflated the two.
Do the other 15 really did answer all the questions that the appellate division was looking to have answered on the remand?
Oh, they didn't have any of them.
No, I understand they didn't, but do they answer all the issues that the appellate division was looking for? Because it seems to me the appellate division was looking for an answer as to this, the array that was in the record.
Right, and I'm saying that array shows. I understand
your argument, but all I'm saying is that the addition of the other 14 packets does not answer all of the appellate division's questions, does it?
I guess what I'm saying is the packet, as it relates to the administration on August the 8th, answers the questions we believe that they had. The thing is that all the packets together, not only, well, the questions about August the 8th are answered, but in addition to that, the other packets also happen to show the failure of this agency or this particular entity to comport with the Attorney General guidelines in Delgado. But the questions that they had are answered in the packet for the 8th, for August the 8th, which is the date that she actually selected a photo.
Anything else you'd like to add?
There's just one more thing. Because there was a discussion, and this, I'm sorry, bounces back to the Miranda issue, but there was a...
Try to do it succinctly.
I will.
We're on time now.
There was a question about concerns about the confession, and I just know, and this is in my brief, so I will be very quick, but we've noted, the U.S. Supreme Court noted in Spano, and this court noted in Fauntleroy, that what we're concerned about is not whether or not an individual spoke the truth, but what we are concerned about is that law enforcement also obey the rules. And that's our concern here, that it was in the Miranda issue, that it was involuntary, they didn't obey the rules. And that's just as much of concern for society as anything else.
Thank you. Roger.
May it please the court, I would like to first respond to a couple questions by Justice Fernandez-Vina. Justice Fernandez-Vina, you raised the issue of the phone call, the initial phone call. That it would be already required under the 2001 Attorney General Guidelines, which on number 3, page 3, requires avoid saying anything to the witness that may influence the witness's selection. A statement...
It says avoid, but it doesn't say record.
That's correct.
Which is what I was asking about, whether the public defender required a recording of that conversation too. I understand what the Attorney General Guideline says, but it doesn't say record. It just says avoid.
That's correct, Your Honor. And in the future, that would be a required recordation or documentation, because Rule 311C8 would require that to come in. But the concern there is really about, the detective who calls the witness stating, look, there's been a big break in the case. We know we've made you come in for...
Well, you don't have to give me examples. I know what you're concerned with. I just wanted to know if it's required to record it.
Understood, Your Honor. And the second question you asked was about how do we know that the dialogue here was not more than what is in the forms? The answer is that we don't know what the witness said when she identified the picture. And that is the critical piece of information that we lack. So even if there was no dialogue before that, she said something when she picked the picture. She definitely didn't say what was in the form, right? Because the form is fill in the blank, this is the person who raped me. It's not what she said when she identified the form with the officer.
How do we know that? How do we know that someone didn't say the line begins as being that of the, and then guy who, and then it says grab me, and on it goes. How do we know that isn't an account of what she said?
Justice Patterson, it's not because it's a fill-in-the-blank form. Some of those words which you just noted are on the form itself, and we also don't really need to.
As being, it's not a model of grammar, I'll give you, but it's the sentence starts with as being that of the blank, who blank. The rest is, there appear to be 6 lines left for someone to write down something, and in this case, there are 2 lines where someone wrote down, so really most of 3, something that was supposedly said by the witness. So why are we saying there's no account of what she said when she identified the photo?
Justice Patterson, I didn't mean to say that there was no account. I'm just saying that there is not the account required under Delgado, which lays out a bit of a hierarchy. It's not a menu of choices. It is verbatim recordation, if preferably electronically, and then if that's not possible, a detailed written summary. And if that's not possible, then as soon as possible, write down what occurred at the identification.
But how do we know this isn't either a verbatim account, even if it's that the first couple of words are on the form, or a detailed written summary?
We don't know because law enforcement failed to record according to Delgado. That's the reason why we're speculating. And Delgado was supposed to prevent the type of colloquy that we've been having today, because it would have the recordation in the record, and we could review an objectival.
We have a hearing, so I'm listening to your exchange with Justice Patterson. Justice Patterson is suggesting that little fill in the blank may have been precisely what the witness said. There is a person who raped me. We just don't, the way this whole process went down, we just don't know. We're all speculating at this moment as to what, if anything, what precisely was said at the time, correct?
That's correct.
So what do we do about it if we're in the realm of speculation?
So a hearing would be better than nothing, but in this specific instance, I can talk about this specific instance in general as well. This identification procedure took place in August 2011. It would be very difficult for law enforcement and the witness to really determine what was said during procedures that took place 9 years ago.
So you're probably right about that, but we can't be 100% certain. So is the better course to send it back for a hearing, and then maybe the witness or the police officer will have some incredible recollection, or they'll say precisely what you've suggested. How could I remember what happened 8 years ago?
The ACLU's position is that the identification should be suppressed because of Delgado. Delgado was simple and clear. It said, as a condition of admissibility. But in addition, there's so much indicia of suggestibility in this case. I mean, we shockingly heard a concession that the officer involved in the very identification procedure in which an identification was made was not blind. But there are far more, and I'm happy to go through all of them. The dialogue was not recorded. The witness's statement of confidence in her own words was not recorded. The detective who called the witness was the one who was involved in the case. And this is something that was recently discovered. There were multiple viewing problems that infected these identifications. So over the course of the 15 identification procedures, 5 photos were shown to the witness twice. And
Did they include the defendant?
They did not include the defendant, Your Honor.
So how does that compromise the identification on viewing 15?
Well, what we know about the science of multiple viewings is that it can operate in 2 ways. It can point out a specific suspect, or maybe even a characteristic of a specific suspect, or it can identify to the witness someone who is not involved, who is not the perpetrator, because she has seen the photo before. Just to give you an example, in one of the photo arrays, 5 out of the 6 had been duplicate photos. And the only one that was new, the witness focused on a little bit and said, maybe there's some similar characteristics here.
None of those repeat photos were in the array that she finally selected from.
That's correct.
If you knew all the information that you have and that you've included in your brief at the time of trial, before the plea in this case, would you have argued for suppression, or would a hearing have been the appropriate course?
Before the trial court? We would have argued for suppression because...
Would you have argued for suppression without a hearing taking place?
Yes,
Or would you have said, Your Honor, we're entitled to a hearing to explore this identification?
Yes, Your Honor, for 2 reasons. Delgado, as well as the fact that it would be very difficult to recreate the dialogue even 2 years after. So the trial court heard the Delgado motion in 2013, in July 2013.
So you'd make that argument, and the judge will say, hey, maybe you're right, maybe you're wrong. Let's hear from the witnesses. And then what would you have said? Oh, no, don't want to hear from the witnesses?
Thank you, Your Honor.
That's correct, Justice Simple, and that's exactly what we would say.
But then aren't we essentially left with, you think you should get suppression now because more time has passed?
More time has passed, memory has degraded, and in all likelihood, confidence will increase in the identification that was made. So that's significant prejudice to the defendant in this case. And Delgado was clear. Delgado set up a per se rule. And in addition...
But Delgado, it was not just about suppression of the identification. It also was concerned about creating a record, asking the kinds of questions that you and others have been asked about today, designed to elicit information that if the identification does get before the jury, it can be used by defense counsel to undermine the jury's confidence in the identification. So I feel like the position you're taking is unduly constricting the multiple purposes that Delgado had in mind in preserving as much of a verbatim transaction as we can of the identification process, either at the time or thereafter with a hearing. And yet you're fighting a hearing at this stage, assuming that nothing of value could have been produced. I don't understand that.
Just Vivek, I apologize. I don't mean to fight a hearing. I'm just saying that in terms of the lexical ordering of the best ways we could address the issues in this case, I think suppression would be the best way to address it, but a remand could also be appropriate. And I would just like to go through the indicia of suggestiveness that exists in this case, because I didn't go through all of them. The additional one that I didn't mention was that detectives actually involved in the investigation, now we know the final one as well, but on at least 2 other instances were administered the lineup in this case. And unless there are any other questions, thank you. Thank you.
Mr. Lemuro.
Good morning, Your Honors. May it please the Court. Justice Albin, you hit the nail on the head. This case is a recipe for an involuntary confession. The ACDL is urging this Court to adopt a per se rule that a confession based on a false promise of leniency, direct or indirect, is involuntary. For example, if you tell us what happened, we'll give you PTI. That's the Reha case. If you tell us what happened, you won't get in any more trouble. That's the Puryear case. If you tell us what happened, you won't go to jail. That's this case. The police don't have the authority to make those promises. They can't make plea bargains. Worse, these promises are in direct contradiction with Miranda. Miranda says anything you say may be used against you. These promises say anything you say will help you. The truth shall set you free.
What are you relying on in arguing that the police told him he would never go to jail if he confessed? And I'm referring to the difference, no surprise, between nothing's going to happen tonight or some version thereof, and you are going to be given counseling and you're going back to your regular life.
Right. So, Justice, one thing I want to point out is that the record was impounded for me. I don't have the ability to talk specifically about the video or the transcripts.
Okay, I apologize. Because yeah, okay, so you haven't read it, you haven't looked at it.
I'm speaking to this court generally more than anything.
Oh, I see. I'm sorry. I didn't realize that you were not given access to that.
But what I can say certainly is this, Justice. Statements by police officers that suggest or directly state that you're going to have leniency, it's in direct contradiction with Miranda. Even if there's some confusion, which apparently is what happened in this case, there may be some confusion, that invites error. It invites error. It puts trial courts in an impossible position.
You're not in a position to argue that he was or was not told he would never go to jail if he confessed, in this case.
I'm not in a position that's right, Justice.
Thank you.
When you talk about leniency, do you differentiate at all offers of help versus offers of something more specific like counseling or treatment that suggests diversionary activity?
I believe leniency means a consequence of the confession. In a diversionary program, that's very clear. That's
Yeah, PTI for sure, but
Right.
assume some kind of
Help.
mental health,
I actually think that help is
Alternatives.
more compelling, Your Honor. The reason I say that is I deal with clients all the time who have addictions and are acting on impulses. They want help more than anything in the world. They want it more than the diversionary program. They want it more than being promised they're not going to go to jail. They really want to stop what they're doing.
So tell us the contours of your position, your per se rule. If, and you've seen many of these interrogations, if an officer says, you're not a bad guy, we know you're not the person that did this, we want to help you, we want to get you beyond this, would that fall under the per se rule that you're suggesting?
No, deception is okay. The per se rule is going to be a promise or an indirectly of leniency. So getting you help, it would have to be.
Isn't it really a promise of anything they don't have any control over, the officers don't have any control over,
Yes.
like PTI or no jail?
That's
But
exactly.
deception's okay, but it offers, what you suggest, it offers as to events that the officers have no control over because it's within the court's ambit, they're improper.
That's
Isn't that
exactly
really what you're suggesting?
so leniency has to relate somehow in the offer to something less than jail, or some alternative to the criminal justice system.
Yes.
I'm trying to understand
Okay.
what you mean by leniency.
I'll give you an example. We practiced this, we mooted this, and one of the examples I said was if the police officers say, tell us what happened, I'll buy you a pizza. Okay? That's okay.
Okay.
Because that's not toward the ultimate consequences of what he's confessing to. Now, PTI is. Not going to jail is. Get you into rehab is. And those are things that that the police cannot do. They don't have the authority for it.
Boiling it down,
Yes.
it seems to me the examples that you're given are ones that would directly contradict the promise that is made to the defendant, that anything that you say will not be held against you. And if they're making promises that are directly contradicting that guarantee, then there's a violation.
I could sit down on that argument, Justice. That's exactly what we're saying. These positions, it's an interrogation technique, and the court has the opportunity to clarify this for law enforcement and say those type of promises are going to muddy the waters. Those type of promises are going to bring error and give trial courts, the appellate courts, and this court put you in an impossible position, which is to punish police misconduct, because that's really what this is. It's illegal conduct versus heinous crimes, like in this case. You have to put that balance into order. Miranda is a perfect example of taking that balance away and saying we have a clear-cut rule. It's not going to be gray. It's a clear-cut rule. And that way you don't have that type of balancing issue. So yes, Your Honor, that's exactly right.
Anything you'd like to add?
No, I think that's it, Your Honor.
Thank you.
Thank you.
Ms. Rowe, rebuttal?
Yes, Your Honor, thank you. I would like to make one point clarifying what the record consisted of in this case in the appellate division, and then I'll move on to 3 brief substantive points about the Miranda issue. So with respect to the Bloomfield Police Department identification packets, I would be remiss if I didn't inform the court that the trial court had these identification packets, and thus in the course of discovery, the defense would have had these identification packets at the time of the motion in the trial court. They were not in the defendant's appellate brief in the appellate division, and me being a relatively new lawyer did not take it upon myself until after the opinion came out to complete the record on reconsideration. But it's important to emphasize the defense always had these identification packets at the time, from the time of the trial court motion. They had the packets at the time of the appellate division briefing part, or they should have had, the defense had it at the time of the appellate division briefing part, and then I supplied the appellate division with the identification packets that were always part of the record on reconsideration.
And were the arguments that are now being made about those packets in terms of repetition of photos other than the defendants and so forth made before the trial court? about suggestiveness based on the packets.
I don't believe that they were, but I would hate to be quoted directly on that, Your Honor. I don't believe that that's mentioned in the record. So so there were already, it was essentially that it was the recording that was the nexus of the defendant's argument. Below, everybody had the identification packets, and they should have been included in the defendant's brief when he filed his appeal in the appellate division, because he had these in his possession. So I would be remiss to allow the court to believe that the state didn't provide these at the appropriate time. The state, in fact, did. With respect to the Miranda issue, there's 3 points I'd like to address. First, with respect to who set the stage for getting defendant counseling, that context is important, and it's a lens through which to view the entire statement. Second, the importance of the video that Justice Solomon touched upon when discussing this with defense counsel. And finally, third, the opportunity that defendant had to explain. Justice Patterson had discussed with defense counsel that it was meaningful that there was a minor before, and what conversation happened in the context of everything happening so quickly, and why is this different. So first, on page 58, you see that counseling is brought up for the first time in this statement. It's not the detectives who bring up counseling. Defendant affirmatively brings up counseling for the first time. And then I believe it's Lieutenant Krentz who follows up and asks, was counseling part of your parole? Defendant responds that it had been. Defendant certainly would know you don't end up on parole if you hadn't first gone to prison. Defendant understands the timeline of prison and rehabilitative help after being released from Avenel and from prison. He affirmatively brings it up. He explains that he understands that it's part of parole. And then
ask you to try to cut through these points quickly.
Sure, absolutely.
We understand the first.
And then Justice Solomon touched upon the video. It's important to review the video in this case as the trial court had. And the trial court made specific findings after reviewing the video. At page, in the 5th transcript, page 9 through 21, not page 9, line 21 to 25, and same transcript, page 8, line 23 to 9-2. His demeanor was relaxed, and he engaged in an exchange with the officers. He pointedly asked about counseling. He pointedly asked about jail. He gave pushback. He was hesitant in some places and expressed his hesitancy, and in other places he volunteered information, which leads me to Justice Patterson's discussion with defense counsel. The chance to explain. Defendant was told at, I believe it was page 72, so before they began getting into the particulars of the first rape on June 18th, they explained to him there's 2 sides to every story, and this is the way in which it's meaningfully different from the statutory rape case. In that case, it's cut and dry. It is against law to have oral sex with a 16-year-old girl. In this case, defendant seemed to be setting himself up for a consent argument, and Lieutenant Krentz honed in on that. He said, I understand that there's 2 sides to every story. We just want to reach a reasonable conclusion about what happened. This is your opportunity to tell us what happened, and he explicitly says, we're not going to put words in your mouth. He explains that this is defendant's opportunity to present perhaps facts or a version of the truth that would either exonerate him or certainly mitigate the severity of the crime. Defendant took that opportunity. He attempted to frame it in the form of a consent argument by adding details about how he didn't harm them, how he didn't rob them, how he assured them that he wasn't going to do either, discussing favorite sexual positions and making sure he told the officers that. All of this gets to one thing.
So you ask us to look at page 72, and he says, I don't want to sit here and try to, basically what happened last time was they got me to confess to something I didn't even do. That's 72. And then you turn to page 74, and they're saying, don't worry, you're not going to jail. I don't see how that's helping you.
With respect to page 72, so defendant says he confessed to something he didn't do, but he's
basically saying, I don't want to confess.
His perhaps feigned confusion is based on the fact that he says that the 16-year-old girl consented, and he tries to make something of the consent of the 16-year-old girl and something of the alleged consent of the women in this case. And he eventually says about that prior confession that what he said was true. I don't have cites
I'm just
for
looking at proximity. 72, I don't want to confess, and then 74, don't worry, you're not going to jail.
74, don't worry, you're not going to jail. And then on 77, he says, I just don't want to jeopardize all the stuff I've been trying to rebuild.
74, just to be clear, am I going to jail tonight? Is this going to be my last meal or something like that? No, not at all. There's nowhere where he says I'm never going. He's told he's never going to jail.
There's nowhere in any of the statement that he is specifically told you're never going to prison. This is a mere deflection, and when viewed in the rest of the conversation that continues on to page 76.
Because this is rebuttal, I'm going to try to bring this to an end. Anything you need to add?
Yes, he expresses hesitation, he pushes back, and then eventually it seems as though he does calculations, and as the trial court observed, he was calm and relaxed throughout.
I have one last question. Where in this transcript do you say he initiates the idea of it being consensual? Because I'm looking at page 77 and thereafter, before he begins to confess at around page 81, where the idea seems to be planted by the police. You didn't hurt them. You were, they didn't say that you were rough. So I see a number of things where it looks like the idea of him it being more consensual seems to be coming in through the officer's testimony.
They're riffing off of his earlier comments about the 2009 sexual assault, where he attempts to defend himself by saying, well, the truth of that matter was, and I told the truth, that this girl wanted to have oral.
So from that statement, you think that's where they had the ability to suggest that he was going to pursue consent in this one?
Yes.
Okay.
Do you know the basis for the sealing of the record in this case?
Because it's a sexual assault case.
Just categorically?
To protect the identities of the victims, yes. And I should add, the appellate division confusingly changed the caption of this case to LH. Our court rules provide only for abbreviating the names of sexual assault victims, not the names of defendants.
Thank you.
Thank you.
Thank you to all counsel for the very helpful arguments. We're going to take a brief recess. Mr. Faraji, you didn't have the record in this case either. Did you have access to any part of the record?
I didn't have access.
You did, and they just picked on Mr. LeBron. Understood completely. Thank you. We'll take a break for just a few minutes. We'll be back.